ladies and gentlemen, we probably should get started to get through the two papers this morning in a question session. And what a great way to start the day in Melbourne, just as the sun is rising. My name is Caroline Kenny, and I'm a silk on Green's list. I practice in commercial law, but specialise in property, insurance, trade practices, and consumer law. The topic for the breakfast briefings this morning is owner corporations under the Owner Corporations Act of 2006, their regulation and implementation and construction problems that arise under that Act. At some point during the course of your practice, you will no doubt encounter a problem with owners' corporations and the problems that arise. Whether it be enacting for a tenant, enacting for an owner's corporation, or simply enacting for a person proposing to purchase of a plan of subdivision. The frequency with which disputes arise in this area is demonstrated by the fact that as of January of this year, VCAT now has a dedicated list in relation to owner corporations disputes. Our first speaker this morning is James McKay. Before James was called to the bar, he was a solicitor at an inner suburban law firm. At the bar, James has appeared in a number of important and significant cases in VCAT and in the Supreme Court. This morning, James will highlight some of the important features of the Victorian Owners Corporations Act, and will do so in part by reference to a case in which he has recently appeared. Before I hand over to James, I just should mention something about the procedure for this morning. There will be a short coffee break after James has done his presentation. We will not be taking questions at the end of James' presentation, but there will be a session for questions on both papers after the second speaker, Mitch McKenzie, has delivered his paper. So I hand over to James.
Thank you for that warm welcome. I think Ms Kenny's right when she says that if you practice generally in the areas of commercial or property law, then it's going to be difficult for you to avoid seeing these disputes relating to owners' corporations, and it's an area of the law that I think will have increasing relevance as time goes on. We've already seen a substantial growth over the last few years, which I think is to do primarily with two things. First of all, there's the passage of the Owners Corporation Act 2006, which I'm sure you're all somewhat familiar with. The breadth of regulation in that statute has basically increased the number of provisions that apply and that regulate owners' corporations to an extent not seen before under the Subdivision Act. So there is going to be new questions and new provisions to be considered by the tribunal, and that process is already largely underway in the new list that's been created to hear these matters specifically. Probably the other reason why owners' corporations will continue to grow in importance is much more of a practical one. As you all know, the population of this city is increasing quite dramatically, and the government is suggesting that we're going to have to accommodate up to 620,000 new households over the next 2 decades. And in order to make sure that that happens in the best way possible so that new residents have access to all the existing infrastructure and facilities, the government is saying that we're going to have to dramatically increase the density of the inner and middle suburbs, and that of course will happen through the improvement of a greater number of residential apartment blocks. And of course, leaving aside some of the relics of the past, such as stratum title and company share and whatnot, pretty much these days every apartment block in this city is governed by the owners' corporation regime. And also, it's not just the mere fact or the number of people that are regulated by it, it's the nature of that regulation and of the people's relationship to each other. If you have a bunch of people living on top of each other and side by side in fairly close proximity, and you have an act like this that allows them to regulate each other's affairs and sort of forces them to cooperate in this joint enterprise of maintaining the property, attending meetings, juggling finances, all those kind of things, then the scope for dispute is always going to increase fairly dramatically, and people as in any case where they're asked to cooperate, will fall out, and there'll be matters that lawyers like us are required to look into and to assist people on. So the structure, I think the theme that's really evolved here today between myself and Mitch is to try to look at some of the new developments in the area. And in keeping with that theme, I think it is best to look mainly at recent cases, although what you find in this area, I think, is that the issues that do pop up often are the same issues over and over again. And I think it's necessary, as well as looking at the new decisions, to go back and look at some of the classic sort of early law that related to the Subdivision Act, and to see the passage of the law as it's evolved and how it deals with these common issues that we see over and over again. The reason why I chose the first case is not only is it recent, I actually appeared on it last week in the VCAT, but it seemed to be a very good case study because so many of the common disputes that I see, and interesting ones, arose really in the same case, which ended up being quite procedurally complex and involving a number of different hearings before the VCAT and a number of different parties. What had happened was a tenant had moved into a typical apartment block, which it was a strata block, 13 or so units, and she'd noticed immediately that the water pressure, according to her, was deficient. She said she was unable to shower and had to go and wash at a relative's, and her appliances like dishwashers and washing machines weren't working properly. And as you can imagine, if she was telling the truth, then that would have had a disastrous effect on her ability to manage her life, basically. And so she made a complaint to the leasing agent initially, who sent a plumber out, and the prognosis wasn't good. Apparently the defect was going to cost in the order of $15,000 to $20,000 to rectify. And according to the plumber, or to this plumber, the defect was situated in the common piping further down the line, so that it was basically an owner's corporation issue. A complaint was then made to the managing company that managed this particular owner's corporation, and she sent out Yarra Valley to check that everything was okay with the pressure at the mains, at the front of the building, and it was, which narrowed it down and meant that the problem had to be somewhere inside the apartment block or the common property. A second plumber was then sent down by the owner's corporation, and of course a differing account of the problem was given. And as a result of that, some fairly small remedial works were carried out, fairly cheap remedial works I might add, and the tenant still complained that the problem had not been remedied. The tenant's next reaction was to go to VCAT and issue a proceeding in the residential tenancies list, only against the landlord at this stage. And it seems, and this is going to be the first aspect I'll discuss, there was an order made against the landlord, even though the evidence tendered at that first hearing did not really disclose the location of the problem or the nature of it. It was simply assumed that whether or not the defect was cited in the property or outside it, that no matter what, if the services to the property were impaired, then the landlord, under his duty to repair in the lease, was obligated to fix that problem, which is the first issue I'll be discussing with you. In that first order was made that the landlord had to fix the problem somehow, whether he got the owner's corp to do it or whether he did it himself. Leave to reapply was given in case compensation needed to be sought by the tenant, and also in case the work was never done. And of course, the claim was that the work was never done. It came back before VCAT, and a claim for compensation was also made in addition. Only at this stage it was a different member this time, and they said, well, isn't there some issue here with common property and the owner's corporation? And after some discussion with the bench, the parties then adjourned and went off and changed the proceeding quite drastically. The landlord issued an entirely new proceeding in, I believe, just a civil list against the owner's corporation, the management company, and also the director of the management company personally, the person they'd been dealing with over the phone. Likewise, the tenant joined those three respondents to her action, so we have now two proceedings which were then consolidated and came back before VCAT in March. Due to a good reason which I won't go into, none of the three respondents in either action showed up, so we just had the landlord and the tenant effectively lumping the blame on the owner's corporation and other respondents. And the orders were made against those three parties to cover the damage, basically, to both parties, jointly and severally. Where I came in was to try and get those orders set aside and to have a rehearing, which I succeeded in doing. partially due to the good excuse that was given by the owners' corporation, the manager and the director as to why they didn't show up, but also due in a large part, I think, to the nature of the orders that were made and the questions of jurisdiction and approach that were followed in VCAT in the early stages, which placed the orders, I think, in a great deal of doubt and meant that the whole thing had to be really reconsidered in order for a fair hearing to result. The rehearing, I think, will centre very largely on it. It'll be a battle of evidence between two plumbers. The contention of the director of the management company is that the problem never existed in the first place, that this tenant is pretty much lying in order to get a rent reduction and then move off to the next place and probably do the same thing there. So it's quite a serious allegation, and the assertion is that there is no problem at all, or it's a very minor problem and this person is making a big deal out of it only for financial gain. And the evidence, of course, will centre on whether the defect exists at all and whether it's located within the private lot or out in the common property. So those things I can't really obviously go into because the dispute hasn't happened yet, and it's really a factual issue that won't so much affect the law. But for the purposes of the discussion, I wanted to pretend as though the tenant's allegation had been made out and we did have a serious problem, and to look then at the various issues that arise out of this case study, which I think are interesting. As I said, the first point here is this dispute with between the landlord and the tenant, and what the landlord's obligation is in all this, arising under the lease and the Residential Tenancies Act, for problems that may well originate on the common property. As you know, if something within the apartment breaks down, like the basic obligation to repair is triggered, then the landlord has a strict liability, effectively, to go in there and fix it and to make sure everything is okay. The question is, does the same or a similar kind of liability arise when the problem is an interruption of services but caused by a defect out on the common property? At first blush, I would have thought that the landlord had a very good argument here. His fittings, his pipes, so as far as he could prove, were working perfectly, and it seemed almost certain that the problem was located further down the line. So in terms of the obligation to repair, what obligation could he possibly have? His fittings, his apartment were all perfectly in order. The problem was down there. So to make the order against him originally, I think, was controversial. However, on further inspection of the Residential Tenancies Act and the regulations which prescribe a standard form contract, there is actually something in both that attempts to deal with this problem. It's Clause 5B of the prescribed lease and Sections 68, 1 and 3, or particularly subsection 3 of the Act. And what it does is it seems to put an obligation on the landlord to take reasonable steps to make sure that any problem originating on the common property that affects the tenant's usage of the land is rectified. So doesn't have the same strict onus of just simply fixing it if it's the same way as if it's an internal problem. Rather, his duty is to do his best to make sure the owner's corporation gets onto the problem and fixes it as quickly as possible. Now, the problem that is it's worded in a way that's rather obscure and lends or creates issues as to whether the intention was to confine it to very narrow circumstances or whether it applies in the normal situation where you just have a multi-lot apartment and a landlord who owns a lot within it. If you look at the language, you might see what I mean. It says, if the landlord owns and controls the common areas relating to those premises, then he must take reasonable steps to ensure that the defect is rectified. Now, those two notions of ownership and control, which condition the whole section or the whole provision, create great difficulties in this area because, as you know, if any of you have lived in an apartment block or own a unit within it, you don't have necessarily a great deal of control over the owner's corporation or the common property. It's really jointly owned land that everyone has an equal share to, and it's administered by the owner's corporation, and you wouldn't say that it's something that you control. Likewise with ownership, in this context, that's a very difficult concept. The Supreme Court in 2004 had to consider a situation as to whether the individual lot owners actually own the common property. And the finding, surprisingly enough, was that they don't own it, that it is vested, in fact, both under the Subdivision Act and now under the new Act, in the owner's corporation itself, and that there's a mere sort of equitable interest or underlying interest that vests in the lot owners. So to consider our two words, ownership and control, our two conditions, both of them are highly dubious, I think, and there's a question as to whether the section applies much more narrowly and whether we can use it in our day-to-day practices to assist tenants against landlords or to advise our landlord clients. Some guidance now has come from VCAT in the case Zador and Hocking, which was somewhat similar. It involved security gates at the front of a property that were broken in a burglary, and then the owner's corporation seems not to have fixed it for, it was about, I think, 10 days to 2 weeks. And then probably the same burglars came back, took advantage of the existing defect in the security wall, came back in, stole a bunch of tools out of a tradesman's car that were uninsured. So his lawsuit was against his landlord and also the owner's corporation. And he sued the landlord using these provisions that I'm discussing. He said that you didn't get onto the problem quick enough and chase up the owner's corporation and make sure that it rectified the problem. And you own and control that common property sufficiently so that the section applies to you. VCAT agreed with that proposition, and ultimately the landlord was not successfully sued. The evidence made out that he in fact had used his best endeavours to fix the problem. So although the claim was unsuccessful, VCAT did say that it does apply in this circumstance. You don't need any sort of special control, or you don't need to own lots of apartments within the block and therefore have some kind of controlling stake, or it's not otherwise narrowed in any way like that. It applies in the general circumstance where you own a block in a multi-unit apartment and you're a landlord. If that's the case, your obligation is to use your best endeavours to fix a problem on the common property. Now, the next issue that arises both in the case study and also that was considered in Zador as well was this notion of, can the tenant sue the owner's corporation directly for a problem like this, or for any other problem when there's a breach of the Act or some legal duty that affects the tenant's enjoyment of the property? The answer under the old Act seemed to be no, and Zador considered that question. In order to sue the owner's corporation, the tenant in Zador relied on the Residential Tenancies Act itself, and the argument was that it's, that classic provision in the Act arising under a residential tenancy. The argument was that this dispute was closely enough linked with the lease to say that it arose under the residential tenancy agreement. And that was rejected for obvious reasons. There's no real lease between the owner's corp and the tenant, and that was really just a spurious claim to bring it within jurisdiction. The other argument was under the Fair Trading Act, and the argument there was that the owner's corporation provided services that the tenant benefited from, and therefore it was a consumer trader dispute within the meaning of the Fair Trading Act. I think sections 108 and 9 are the relevant ones. That was of course rejected as well because the services here were being provided to the owners of the lots, and it was incidental that there was a benefit passed on to the tenant. So the whole claim against the owner's corporation was dismissed, and Zador seemed to support the authority or the proposition that a tenant does not have recourse against the owner's corporation. Perhaps he could go to a court of law and sue in negligence, but he had no jurisdiction in VCAT to bring the claim cheaply and easily. The new Act seems to have reformed that position, and there's now an express provision dealing with the problem and creating a direct right and a clear right for the tenant to sue the owner's corporation directly. That is found in section 163, subsection 1, paragraph D, which just simply says an occupier or former occupier, so that's good of course if the tenant's moved out, they can bring an action against the owner's corporation if there's an owner's corporation dispute, which effectively means any kind of dispute under the Act whatsoever. As to the proper parties and those kind of issues, the only other point I'd seek to make is some of you may have been surprised that the director of the management company was joined as a party as well, which I think is perhaps the most dubious aspect of the original proceedings. People talk very frequently these days of the corporate veil being pierced or eroded, and sort of imply that the traditional rules in Salomon that meant that a company was a separate entity and was entirely separate from the people that ran it has somehow been eroded. I think that those claims tend to be exaggerated, and without going into the issue too much, I've put a footnote in the paper that has an interesting High Court case that discusses this idea of acting as the mind and the arms of the company and the extent to which a director or employee or officer can hide behind the company and sheet all the liability home to the company. And the approach does still tend to be that if I'm running a company and my company is on the letterhead and is dealing with the people involved, that their action is against the company, not against me. And I think it was highly unorthodox for VCAT to actually make the award, even on the basis it did without the respondent showing up, against the director personally. The only other issue with parties is the management company. There now also is express rights on the part of the landlord and the tenant to sue a manager for a breach of duty in VCAT. So that's now also been clarified if there was any doubt on that point earlier. I'll move on now and talk about the next issue I think that the case study raises, which is a fairly basic one, but one I think that still leads to problems very frequently. And it's important as well because the issue is identifying where the common property starts and ends and what the boundaries are. And of course, you can't work out the location of a problem if you don't know whether a particular wall or feature is common property or not. So I'm not going to, I know you all know how to read plans and whatnot, but I did want to talk about one issue that seems to have arisen on a number of occasions and a question that's been asked to me quite frequently, which concerns exterior walls and whether, in any case, an exterior wall can be considered to be owned by a private lot owner, so that, for example, they can cut a door in it or, use it as their own land and not have it deemed common property and therefore subject to the majority rule. The situation usually arises when there's a courtyard that surrounds a private lot, perhaps in the corner of a block. I've put a title search on the back of the paper as an annexure, which I think gives a pretty good example of the kind of thing I'm talking about. You can see if you look at units 1 or 2 that the cross-hatched areas, there is a legend somewhere else on the plan which I haven't put in there, but I can assure you that the legend says that those cross-hatched areas are actually contained within units 1 and 2. So the issue therefore is if you look at those walls to the north or along with unit 2 down the west there, are they up to the ceiling height common property? If there's a pipe, in our case, if the pipe had gone through one of those walls, would it be an owner's corporation problem, or would the owner's corporation have an instant defence and be able to say, well, no, that's your private land. Anything below the roof in that wall is yours. Many people have come to me and sort of said, well, we don't think that there can ever be a situation where a wall like that is owned by a private lot owner and that there's some presumption that walls that are structural or exterior walls are always common property, no matter what. All I'd like to say quickly is I think that there's good reason to perhaps doubt that approach, and particularly with strata plans, there'll often be situations where either part or all of an exterior wall, in my submission, would be owned by the private unit owner that owns the exterior unit. If you look, for example, with strata plans, you're all familiar, this is a strata plan, for example, you can see there's no measurements and the boundaries are defined by walls and physical features. If you look to the second schedule of the Subdivision Act, 1988, and particularly Clause 5, it says that if ever there's physical features used to define a property, then the boundary, or to define a title boundary, then the precise boundary is located in the median point of that wall or feature. So you can see that even in the basic default position under the Act, the Subdivision Act, half of an exterior wall will very commonly be owned by the lot owner himself. If you look at units 7 to 11, half of those exterior shell walls are owned by those lot owners themselves. If you look now to where the arrow is pointing, that point on the north between 1 and 12, that north wall of unit 12, that's common property out there where the dot is. So unit 12 owns half of that wall, the interior half, and the owner's corporation owns the exterior half. If you look then a millimetre over and consider the position with unit 1, where there's the cross-hatched courtyard, why would it be that the whole wall interior to exterior would be owned by the common property, when right next door we have a half-half situation. And in Unit 1, the land outside in the courtyard is owned by the lot owner, as is the land inside. So it would seem highly contradictory to have any kind of presumption that walls or structural walls or anything like that are owned by owners' corporations by default. And it's something that, when identification of the precise location of the problem is important, you should look to your plan carefully and not make any assumptions. One of the other interesting issues that can arise in relation to joint walls and this default position under the Subdivision Act is what happens if, say, a wall is got cracks all through it or some kind of defect, and either the cracks are spread throughout the entire wall and you're not really able to say that they're situated on one side of the line or the other, or you know there's a precise problem, like, say, a crack in the membrane that's meant to protect against ingress of water. Perhaps you know that such a problem exists, but you don't know whether it's situated one side of the line or the other, and you're not really able, of course, to cut open the bricks and look at it for fear of damaging the structure. What's the approach there? Well, the Supreme Court considered it in 1980 in the case Body Corporate 5181, which was a decision of Justice Lush. What he said was that the battle there involved this case of a pierced membrane or some kind of deficiency that was letting water in. And there was big evidentiary battles about, where the problem was located and whether it was this side of the line or that side. And Justice Lush said, well, no, the better approach here is just to treat it with common sense and say that, really, whatever the Subdivision Act says, it's a joint concern, this wall. They both own it. Both should be required to contribute half of the cost of repairing it, and it would be unfair to call it on this sort of ridiculous evidentiary battle that was going on between the parties. So the question is that whether that approach will remain in every case, and whether it sets down a blanket rule that means any kind of issue where there's a median point in the wall and there's a problem in the wall, it's a 50-50 case, or whether there'll be times when the Simon Body Corporate case will be distinguishable. I'd suggest that it is distinguishable where it's absolutely beyond doubt that the problem is situated one side of the wall rather than the other. For example, in the case study, if the pipes are going through a wall that has a 50-50 situation due to the Subdivision Act, so there's a median point in the wall, this part's owned by the owner's corp, this part by the lot owner, and the pipe is going through one side rather than the other, and that's clear from the plans, then I don't think there's any licence to apply this Body Corporate 5181 case and to call it as a 50-50 situation. In that case, where the problem can be identified precisely and its location determined, it should fall on the person whose land it's within, quite clearly. So while Simon is a well-known case and one that should be followed when appropriate, I think pays to consider very carefully the situation and work out what the right approach is, and don't just follow the Supreme Court case without any independent thought or judgment. Another issue that arises from the case study and that tends to cause significant difficulties, I think, is the distinction between repairing common property and upgrading common property. The basic problem is that one is an obligation on the part of the owner's corporation. They absolutely have to make sure that any problem with the common property or with the services that run across it are repaired and maintained in the same state that they're in from the outset when the block is first built. Upgrading, on the other hand, it seems quite simple to think what that is. That's just building something new, an improvement, something that's not there originally, that's designed to make living at the block better, an improvement. That requires a special resolution under the Act. The problem is that distinguishing between the two can sometimes be difficult, and a rumour seems to have pretty much circulated, sometimes amongst managers or other people that are involved in their owners' corporations, to say that really any expensive works require a special resolution, and that there's some kind of higher barrier when it imposes a great difficulty for the people in the lot because of the expense. I wanted to examine that proposition and see if there is any truth in the Act that supports it, and whether, if the repairs are very expensive, there's any kind of toning down of the basic obligation to upkeep. One of I think why the issue has arisen and why there's so much confusion surrounding it is that there's not very much in the way of supplementary provisions in the Act to allow an owners corporation to raise the money quickly and easily to fulfil its obligation. What we have there's a provision, I think it's section 24, that says extraordinary funds can be raised by the owners corporation, but in order to do so, if the expense is more than double the annual fees, and that's the combined fee, then it needs a special resolution. So consider the situation in the case study. We have works that may well cost $20,000. They're probably works that they're maintenance and repair works that fix an existing service, and therefore the body corporate is obliged to carry them out. And yet if we then look at how it's to raise the money to do that, then all of a sudden we need a special resolution. So it seems from that as though really is there some kind of tension between those two sections, and what is the situation? Is it true that in a case where the works are expensive that a special resolution is always required? I'd say that that argument is based on an assumption that when the members vote in these resolutions or ballots, that they're free to vote how they choose. I dispute that. I think the only way to read those two sections or to reconcile them is to say that in a situation where the owners corporation must repair a problem, then the members must vote to pass any resolution that's required in order to carry out those works. And if you read the sections in that way and imply a duty on the part of the members, then the difficulty seems to disappear, I think, and the correct procedure would be that the owners corporation manager calls a meeting and explains the law and says to each of the people involved, well, you may not want to bear the expense. You might think that the guy up there benefits more than you, but there's an obligation to carry these works out, so I'll be expecting your vote. And if the votes aren't tendered, then the affected party up the end that suffers from the defect can bring an action in VCAT to make sure that the vote does take place, and the correct parties would be not only the owners corp, but all the individual lot owners that refused to vote in favour of the proposal. Other issues arising from repairs and improvements concern what the standard is. Well, there's a number of cases in the paper which I won't go into that you can chase up yourselves and have a look at, but the basic idea is that you've got to maintain the land or whatever it is sufficiently so that it keeps fulfilling its purpose, which is fairly obvious. One of the things that's been deemed to, or one of the consequences of that, has been that there's an obligation to take preventative measures before the problem arises. So it's not just simply a case of waiting around till disaster occurs and then fixing it then. There's got to be proactive steps taken by owners corporations to make sure that there's enough money there and correct works done to prevent any obvious blowouts. Another issue that's arisen in New South Wales particularly has been whether maintenance and repair extends to cases where the original construction or design was flawed in some way, as opposed to deterioration. It's been held that it doesn't matter either way, that if there's some defect in the building from the outset, then nonetheless this obligation of repair and maintenance still arises. Yeah, okay. The only other thing I'd mention quickly is this point of section 49.2 deals with works for the benefit of one of the owners or one or more of the lot owners at the expense of the others, which leads to difficulties. What happens when a roof leaks, for example, and ruins one apartment? It's a common roof, but the work is for the benefit of that one owner. There's some interesting cases in the paper. Simons again, or the Body Corporate 5181 again, is the first in the chain of decisions. And I ask you to have a look at that because there's some interesting law there and some interesting future questions about how to apportion responsibility for these problems on common property when they benefit really only one person.